Welcome to SF Commercial Property Conversations with Bruce Bean, where Bay Area investments meet expert insights. Get ready to unlock the strategies of commercial real estate success.
So today we're talking with Noelle Bryce, and Noelle is a specialist in estate planning and many other facets of law that would involve probate and estates and property. So Noelle, it's great to have you. I'm looking forward to talking to you a little bit further about all these details that people can potentially avoid in order to save their properties from going into probate. So great to have you, Noelle.
Thank you, Bruce. It's great to be here. Yes, I'm an attorney advisor out of Orange County. My firm that I'm with is Barth Calderon LLP, and we specialize in estate planning and asset protection.
So you started your journey from Glendora High School, grew up in Glendora, and then you went to Georgetown University. So give us a little background on how you got from Glendora to estate planning.
Yeah, I'd love to. I grew up in the Glendora area and found myself very interested in pursuing higher education. So I went to University of Laverne for undergraduate and received my degree in political science and speech communication. And I knew I wanted to go to law school. So I figured if I were going to leave California and all its great schools, it better be worth it. And I still do have a love for governance and public policy and just how government operates. And so one of the reasons why I applied to George Washington was its location and proximity to the DC area, Capitol Hill. It's right there. It's a mile from the White House. And so I really was looking forward to going to law school. If I got into a DC school, which I did, thankfully, I would be able to participate in all of the governance aspects of the law and of society and how laws are made. And it was a privilege to be there during my graduate studies and to participate locally with how lawmaking operates on the Hill and having access to some of the best professors in the country.
So I'm a little curious, you decided to come back to California. You didn't want to stay in DC?
DC is great. Yeah, I still have some family out here, and I have law school friends out here as well in DC. And I say out here because I do a lot of traveling in and out of DC to be with my extended family as well. But California was the right move to go back to because that's where my family is, my immediate family and my existing connections. And of course, the California bar is a great one to have as well. And so each state has its own perks and opportunities and entry into the legal field. And DC is more saturated with government work, and I was interested in that at some point, but I did find my way into private practice and estate trust and estate work, which I still I'm very glad to have ended up here. It was really more of a soul searching expedition of what I really wanted to do and what brought me a lot of reward, which was to work directly with people and help them fix their problems as an attorney advisor rather than necessarily invoking the adversarial system for resolution of conflict, which is very necessary and very helpful, but it's not exactly what I sought to do initially. And so estate planning really bridges that gap for me bridges that dichotomy rather, because I'm able to come alongside clients and advise on their issues, both property, tax, family law, and there's a lot of intersectionality with estate planning. And that's where I am now. You know, whether I'm in California or DC, estate planning is fairly common and needed and necessary across all the states, and it touches and concerns every single person in the country.
So are you mostly consulting to California clientele, or do you actually go outside of state?
So my firm, Barth Calderon, the firm I'm with, it's been around for over 30 years. We serve clients nationwide. And part of that is our presence is only in California. So we only have a California office. However, we specialize in estate planning and asset protection. And so long as you specialize in one area, you are able to advise on that area outside of the state. Some of our partners and associates are licensed in other states, and so we're able to do work in those states without any, further reinforcement. But even in the states that we're not necessarily licensed in, we are licensed in California, so we're able to do work across the country with no issues there. My client base is largely in California.
So let's dive right in. You mentioned earlier Prop 13 versus the changes that came up in Prop 19. So it would be fun to kind of review that. I think some of our listeners may not be familiar with exactly what happened there and how it changed the law. So maybe you could explain that for us.
Sure, yeah. Prop 19 was a California constitutional amendment, which changed a few things to how transfer of property when there's a change of ownership, either through gift or inheritance, how that's treated for tax assessment purposes. But it also had other components in the law itself with regards to disaster relief and being able to transfer your tax basis if you were a victim of those issues and unfortunate circumstances, and if you were of a certain age. And so there was benefits to Prop 19 that I think a lot of people figured would be the right thing to do when they voted for it. But couched within Prop 19 was a huge change with regards to transferring the primary residence of the family. And the prior law under Prop 13 essentially concluded that when the primary residence is transferred from parent to child or parent to grandchild, there is an unlimited exemption. What does that mean? It means that parent to child can transfer a house that they've had for many decades, and they can transfer that tax basis unlimited to whatever the market value is of the house, or the changed in value of the house. In other words, the property will not be reassessed. Property taxes will not be reassessed. That was the assumption under Prop 13. Prop 19 changed that assumption and said, well, a parent to child or parent to grandchild is still able to be exempt or excluded from property tax reassessment only if the property was the transferor, right, the parent's primary residence, and the recipient, the transferee's primary residence.
Mm.
And there was only a $1 million value of tax assessable value that would be exempt or excluded. So it's not unlimited. And what that did for families that were either anticipating on transferring the property, or somebody that passed away right when the law was changed without really any ability to revise their documents or their estate plan, or gain knowledge and make an informed decision about how to transfer this asset. We were all in the estate planning practitioner field trying to figure out, well, how is the assessor going to implement this law? What happens if there are more than one recipient? How is the assessor going to see that? What if they don't decide to live there right away as their primary residence? How much time do they have? And so there was a lot of initial questions, and those initial questions were soon answered. And now we know and understand that the recipient has to live there within the first year as their primary residence, and they have to prove that they've been using it as their primary, typically by filing a homestead exemption form or declaration form with the assessor. But if they change their use of the property, in other words, move out or start renting it or something to that effect, then they lose the exemption and could be reassessed. And when I say reassessed, this could be significant depending on the property, where the property tax bill could triple or quadruple. And in the California market, that's a significant market decision. And typically, if you decide to use it as an income producing property, you'd have to pass down those costs to your tenant if you no longer want to use it as your primary. So a lot to consider for families where before Prop 13, they knew they could pass this significantly appreciated asset to their family loved ones, where it would fall under that parent to child exemption. And there wasn't really a concern whether they were going to use it as their primary or not. In fact, they could turn around and make it a rental and they would still benefit. But those abilities to do those things were taken away under Prop 19. And so now it's just primary to primary and $1 million value.
So I assume there's a workaround so you can avoid this whole tax situation. Is that true?
A workaround,
Well,
in
you
what
put it in
way?
a trust, if you do some other method, if you avoid probate, is there a way to work through this so that you don't end up with this gigantic tax bill?
If you fall under the exclusion, which is parent to child, primary for the parent, primary for the child, then you will not be reassessed.
So that's
That is
the only
That
method.
is the only method. Yes, that is the only method. Whether it's inside of a trust or not, the assessor will still see through that trust to the individual beneficial owner. And so, of course, having a trust is excellent because you're able to avoid the probate court process. Your direction about how those assets get divided is very clear. We keep things fairly private. The trust creator has full control over what happens over those assets. So yes, many benefits to a trust, but it is not going to avoid what happens when the assessor sees a change of ownership on the property. And the only thing we can do is make sure that that change of ownership will not cause reassessment. The only exception or the only exception to the reassessment would be primary to primary, parent to child.
So it sounds like as people get closer to um, the end of their lives, they try and figure this equation out in a way that hopefully would benefit their heirs.
Yes, they will typically be advised to work with an attorney or someone that's highly specialized and knowledgeable in this area, because especially if they're passing assets through a trust, we want to make sure that the trust language ensures that, okay, you want this one child who actually lives in California, who anticipates to stay in California, who wants to use it as their primary residence, is the one who's going to get the property. That we're not fighting about it later after you pass away. And then the trust language doesn't actually say that one person is supposed to get it. And so now we have to negotiate buyout agreements and settlement agreements because the assessor may ask for the trust document and say, well, prove to me how the assets were allocated and distributed. Prove to me that only one child who was supposed to get it ended up living in the property. Now, if let's say four children, let's say all four children get it, and they all four have to live in the property, if they want to keep the tax basis, that's just
Oh,
silly.
oh,
It's very silly in terms of planning. Of course, if there were enough assets in the trust that we can make sure that everybody gets an apples to apples distribution and we can equalize the distribution. One person gets the house, one person gets cash accounts, great. But the assessor may still want to see how those assets were allocated. Otherwise, they do have the discretion to go in there and reassess, even if partially reassessing for the portion that is not being used as a primary residence.
so let's jump to commercial property now. Say that a person has a portfolio of numerous commercial buildings in their ownership. How would they handle that in a trust situation or um, coming towards the end of their life? What should they be doing?
Are we talking about reassessment or just transfer of wealth?
Well, all of the above, actually.
Okay,
What's the best way to transfer it, and what's the best way to make sure that they pay the least amount of taxes?
sure. So Prop 19 also changed what was allowable and what exemptions existed for commercial properties. I believe under Prop 13 it was $1 million in value, and then that was taken away. And so now all commercial property is reassessed regardless. So that just needs to be built into the planning with anticipation that if your child or your loved one or whoever is receiving you inherits this property from you, you can expect the expenses to go up because of the reassessment of property taxes. And so that's just built in part of the planning. With regards to actually distributing the piece of pie, who gets what and how, depending on the size of the estate, it's very relevant to determine, one, for tax purposes, but also for succession of how that business, if it's operating as a business or if it's operating as a real estate portfolio, how those assets get divided. And so a lot of times the discussion with the client about, well, do one of your children really want this? Is this going to be managed by, a property manager, and then they're just going to sit and receive income? Or is this the type of property that requires hands-on involvement? Do some of your kids even care about owning any real property? And so there's a discussion point just surrounding that alone. But the idea with being able to transfer assets in a trust is very simple. We assign the membership interest, or we are able to actually distribute from the trust itself. The trust would typically own the properties directly, or maybe own the LLCs that own the properties. And so the trust maybe says, divide all the trust assets to my kids equally. Okay, whatever the assets are, it might be 100% interested in an LLC or full ownership of a building in San Francisco. That's it. It just gets divided equally. And so it's the job of the trustee of the trust to come in and say, okay, these are the trust assets. The trust says we're going to divide everything equally. Let's talk about that. Do you guys actually want equal pieces of every property, or should we then take the value and appraisals and make sure everybody ends up with an equal value, but not necessarily exact same ownership and shared ownership of all the properties? And there typically is a discussion surrounding the use of that property, or succession, ongoing maintenance, and use of the property. But sometimes the parent transferring it has a specific vision for it, and they know maybe one of the children has been involved in managing it, and they want it to stay with them. So we can build in all kinds of rules regarding management and control and ownership. The creator of the trust really has full control over how assets get divided. And so it really is a conversation that's informed by the family dynamics, the purpose for succession over that asset, and what they're going to do with it. You think your kids will just sell this thing right after you're gone? Okay, then it really doesn't matter. Or is this really going to be an income producing vehicle for generations? We might consider a different type of trust, to not a revocable living trust, but maybe a different type of trust that changes the way the asset gets handed down to keep it in generations, and that make sure it's not sold and things like this. Oh, instead of it being distributed and coming out of the trust, we can keep it in the trust, keep it asset protected, and grow income and grow its value outside of the estate of all the beneficiaries. So depending on the trust that we use and the purpose of the vision of the future of that asset, we could be very creative and end up with the best tax strategy, not only for the client, but for their heirs who intend to receive that inheritance.
So I figure there are certain cases where assets, commercial real estate assets sometimes are, the new step up in tax basis will cause a problem for the heirs, and they typically just have to sell the property in order to pay off the taxes.
So the step up in tax basis is helpful with regards to capital gains tax. In other words, if they inherit the property, they inherited the value of the date of death rather than the purchase price when it was originally purchased. And so step up in tax basis is good news in that regard. The property tax reassessment that doesn't transfer over would be what they also inherit. In other words, they now have a change in the expenses for that property, where the property taxes could go up so significantly and not be within what they can handle financially, therefore would trigger kind of a forced sale scenario. Not that they have to sell it, but it's just easier to just sell it, get rid of it, and not worry about maintaining it and not having a profit.
So yeah, so they end up selling it. They can't afford the property tax. The step up in basis would avoid capital gains, but that in itself may not be enough that they still can't afford to keep the property. But hopefully most commercial properties in at least in California would give you a decent income to where and hopefully maybe it's a triple net lease so you don't have to pay the difference there. So anyway, all fun and games to play.
Yeah, it's all fact specific and based on what's going on at the time. There are, as you are aware of, a lot of rent control legislation, moratoriums post-COVID. Uh, and a lot of times the properties are distressed, you run into habitability issues. And so we're not talking about commercial, offices, we're talking about maybe commercial residential. But with the offices, we're running with the issues of remote work. Remote work is good for a lot of businesses, but not great for commercial office owners. And so that tends to also be an issue with just the negotiating power you have now that a lot of your base of tenants just don't want a big office anymore. It's not part of how they do business. And so yes, you can increase rent, but where is the demand? But on a residential side, it's more of there's a lot of demand, there's homelessness, people are on the street, but the government's also said, well, you can't really increase it more than what's allowable by the law on the state side, and then the county and city ordinances that may creep up. And so those are constantly changing. And you may find a situation where a person inherits an asset in one of those cities where there is a moratorium on anything, and now they're just stuck with the bill. Or there's, a tenant that's protected by the Tenant Protection Act, and you
Oh,
can't evict them. All kinds of reasons to make sure you have proper planning and anticipate the increase in costs and do your best to manage the situation um, as it comes your way.
so I'm curious, say you do have an office building in your portfolio, who determines what the new step up in basis is if if the office building is half empty, does that come into consideration? I'm sure it probably would, but how does that actually happen in real life?
Yes, so the appraisals that come through typically are looking at the value of the land itself and the value of the building itself. And then there would be another appraisal that accounts for the business side of things. How
Hmm.
many of these offices are being rented out? What's your revenue? What's your receivables? What are your leases looking like? In terms of a profitability, if you were to sell the just the land and the building versus the business of actually renting out the building. But my understanding is that the step up in basis would rely on the valuations and the appraisals with all the professionals building in all their formulas about um, the market conditions and allowing for those variables to inform their decision about the value of the property.
So just out of curiosity, who does the government actually do an appraisal or do they accept an MIA appraisal? What happens there?
There are certified appraisers and firms who do this for all kinds of needs. And you would, or the client would, whoever is submitting after a sale for a capital gains analysis, right, would submit the appraisal as they understood it to the IRS. And the IRS might say, okay. Or they might say, no, we don't agree with that. We want you to do another appraisal, or we're going to have to apply a certain margin of error to this and revise the numbers you've submitted to us. And so I believe the IRS has about a 3-year window to close their review. And so within that window, they could certainly disagree with the appraiser, which sometimes we recommend maybe having multiple, and that way you know you have a fair pool. Typical to doing research, for instance, you want to make sure your sample is accurate and correct, and it's not like you want 10 appraisers to look at it or 10 different firms to do the valuation,
Right.
but
Can be expensive.
two is better than one, right? And if you are really concerned about an audit, or really concerned that the delta between what you submit and what the IRS may come back with is going to cause a huge capital gains bill that you have to pay, then you may consider a third appraisal to be worth your time and money, because then you know you're not going to be running into a defensive strategy with the IRS about, well, what really was the value and what was the gain, and how are we going to prove our case? And so the more you can provide in the way of support with your form in your return, the better.
Okay, so what have we missed that people need to know as they kind of approach these trusts and probates and so forth? And if they have commercial real estate, what what are we missing here that they should talk about, that we should talk about?
Well, I sure hope all agents out there, whenever they're working with anyone, would ask them, how are you going to take title to this property? And most of the time with commercial, they're likely taking it in the name of an LLC, which is great. That's a good idea, depending on the circumstances. But the missed analysis here is in who owns the LLC.
Ah,
Because if it's owned by just individual members, well, if those members pass away, then it's subject to their estate. And guess where estates end up?
oh
in
boy.
in probate court. uh, and so just because the property, commercial property in this case, is owned by an LLC, doesn't mean we have a plan for succession for it. And it certainly doesn't mean that we've avoided probate, because all we've done is just put it into an entity. Well, that entity needs to be owned by typically some kind of trust to transfer it privately in lieu of probate. So probate is the court process where transfer of title occurs by the government and through the judge's authority from a deceased person, right? Somebody who passed away, to wherever those assets should go. And typically someone might have a will that says, hey, if I die, this is what I want you to do with my stuff. Transfer it to my kids or to my friend Bob. It really doesn't matter, but the will says to the judge what to do. Otherwise, if there's no will, the judge will just follow what the probate code says. Now, in the instances where there's a living trust or a different type of trust, just a trust mechanism, the trust actually acts as the avenue by which the asset is transferred, not the probate court process, but the trust process as a standalone entity with its own manager of assets, which is called the trustee. And so the trustee, after the creator of the trust passes away, the trustee would step in and say, okay, now I have legal authority as the trustee to manage this trust and whatever it owns. So the trust might own the LLC, which owns the commercial buildings. And then, like we said about earlier in our talk today, that the trust would say this asset gets divided in 4 ways, etc. And now we've avoided the probate court process, and agents across the country, it's a very simple question to just ask, how are you taking title? Have you considered ownership with an LLC? If not, who's going to own your LLC? Do you have an estate plan? Do you have a revocable living trust? Identifying how your assets transfer to your loved ones. All very important questions and relevant questions that add value to the transaction. And a lot of times, Bruce, I see this missed all the time. Maybe not by the more sophisticated real property, commercial property owners, but even those who are there doing a big transaction, they'll create an LLC just to take title to the property. And then realize that their operating agreement is not correct, or it wasn't correctly intended to follow how the asset should be divided, or how income should pass to them, or something to that effect. Or because of financing purposes, they'll have to take title in their own name, but they intend to put the property in the LLC, so they still create the LLC.
Yeah, right.
But where's title? Title's still in their name. And so if they pass away, we're going to probate. And if they get sued, they're getting sued personally because title's in their name. It doesn't matter that they created this other LLC, intended to have it own this commercial property. The reality is the property needs to be titled in the name of the LLC for the LLC to actually be the operating business that controls and governs that asset. And so I see this rampantly happening a lot because the lender, they want personal guarantee over the property with bigger
Right.
loans.
Right.
And they typically won't allow an LLC initially to take on the title and ownership. They might be okay with it later, but not initially, so they can make sure that the personal guarantee is the individual. But then that individual, for a variety of reasons, just doesn't do the final step, which is a grant deed into the LLC.
So, and then plus they don't put their membership into a trust. So kind of a
Correct.
double whammy in way.
Double whammy.
Yeah.
That's correct.
Well, for those listening, I think you better call Noelle right away because this is obviously very near and dear to your family planning. And if you don't have it all figured out at this point, I think calling somebody like Noelle would be a great asset to you. So it's very educational for me today, Noelle, and I look forward to talking to you again in the future. I'm sure there are follow-up questions that we're going to get.
Thank you, Bruce. I'm happy to be here, happy to take follow-up questions. You can email me at noelle@barthattorneys.com. You can also call my direct line, 657-443-6892. Happy to help you manage your assets and protect your assets and make sure your family's taken care of.
Well, thank you so much. That was very fun, very, very educational.
Thank you. Thanks for having me.
That's a wrap on today's journey through the SF commercial real estate scene. Ready to share your story? Visit sfcommercialconversations.com/guest. Your insights could lead the next conversation.